We are back. It is 1:46. What I would like to do to get this started is so what we have set before us now is docket number 1904-00289, extraction oil and gas protested by Wildgrass Oil and Gas Committee. I guess I would like to start with entries of appearance on behalf of both parties. Can we start with extraction's entry of appearance?
Yes, thank you, Chairman Robbins. My name is Jeffrey Storm. I'm with the law firm of Wilburn, Sullivan, Mccord, and I'm here with counsel Joe Pershaw, also with Wilburn, Sullivan, Mccord. And then we are joined today by Jason Rayburn with Extraction Oil and Gas. And we are also joined electronically by Nathan Bennett with Extraction Oil and Gas.
Great, thank you. And now entries of appearance on behalf of Wildgrass Oil and Gas Committee.
Catherine Merlin on behalf of Wildgrass Oil and Gas Committee.
Joseph Salazar on behalf of Wildgrass Oil and Gas Committee.
Okay, and let me sort of procedurally set this matter up. I understand, Ms. Merlin, that perhaps you have a family matter that just arose, and I want to recognize that. Can you give the commission some perspective on your availability today and tomorrow? And I know it may be changing as the moments change, and I'm not trying to put you on the spot. I'm just trying to honor the information that I've received.
Mr. Robbins, before we go any further, and Kate, I'm sorry to interrupt. We just had interest of appearance from Mr. Salazar on behalf of WOGC, but as I understand the trial management order, 1904-00289 is proceeding first, and Mr. Salazar is not counsel for WOGC in this matter.
Mr. Salazar?
Yeah, that's just, this matter is being consolidated. That's what we've been going off of the entire time, but I can withdraw my entry on this, entry of appearance on this, if that's how you want to proceed, is by bifurcating this hearing by the polling application numbers.
And so, okay, so we're taking up 289 first, and I thought that Mr. Salazar was counsel for 289.
No, I'm counsel for 190-600-458. So I will withdraw on that.
And if I may, hearing manager, Chair Robbins, I'm sorry. My understanding that it was procedurally that we would begin with arguments on our motion to dismiss, which was filed jointly by myself and Mr. Salazar in both matters.
Yeah, Mr. Chair, that's where I'm a little confused too, is that we would.
All right, well, let's remove confusion. So what our hearing order identifies is that each party will have 20 minutes to present any arguments regarding the hearing officer orders that were identified in section 2. So that's where we'll start. And so that means we'll hear from extractions attorneys, and we also will hear from both Ms. Merlin and Mr. Salazar before we proceed to the merits of number 289. I'm just going by the last 3 digits, so I don't have to read off the whole thing.
Okay, well then I reinstate my entry of appearance for the limited purpose of oral arguments on the motions before you.
Okay. Okay. With that, I now would like to speak with Ms. Merlin relevant to her capacity to be involved in this initial portion of the hearing officer oral argument on motions.
Thank you, Chair Robbins, and I apologize. It was literally a few minutes before the hearing. I got a text from my husband saying that he just tested positive for COVID. We have 2 children who are currently in preschool, and my mother is with us now. She's gone to get the children. To be honest, I'm a little bit reeling. I don't know what Mr. Salazar had prepared to present the arguments on both motion for both of us. And so I think that's what I'd like to do. Yeah,
So, Ms. Merlin, you were breaking up there just a bit, but I think I heard you say that Mr. Salazar was going to present oral argument on the pending motions. Is that accurate?
yes, sir.
Okay. And then we would then take up, we had scheduled a opening argument by each side for 5 minutes, followed by consideration of 289 and then consideration of 458. But I think I now understand that you're the attorney of record for 289. Is that right?
Yes, sir. And I have prepared an opening argument that I've written down, so I should be able to make it through that.
Okay. And then I think our hearing officer order, or actually, I think it's the agenda, perhaps had it backwards that Mr. Salazar was 289 attorney, but now we know it's Merlin. So I apologize for the agenda indicating that. I'm now moving off the cuff, but right now we were supposed to take up 289 this afternoon, which is your case, Ms. Merlin, and then 458 tomorrow, which is Mr. Salazar's case. I assume extraction's ready to go on either case. Would it be helpful, Ms. Merlin, if we were to flip the script and take up your case tomorrow to give you the opportunity this afternoon to do whatever you need to do?
Yeah, yes, I think I think so.
I only have one concern about that, Chair Robbins, is that my witnesses are prepared to go tomorrow. They can't go today. They cannot go today.
Okay. Ms. Merlin,
I will go today and we will figure it out.
okay. If at any time you need a break to deal with your family, just let me know and we'll take a break. We'll try to move forward with this as best we can.
Thank
that-
you, and I sincerely apologize.
Okay, so with that, I do believe that we are set to hear any argument either side may want to make with regard to the hearing officer orders, the pending motions. And with that, I would look to hearings manager Larson to make sure that she's taking track of time. Is that right?
That is correct.
Okay, and so each side has 20 minutes on the motions. So with that, we would recognize the attorneys for extraction if they plan on making any argument on the pending motions.
Extraction does not intend to make affirmative argument on any of the motions. We would ask that the orders be entered as prepared by the hearing officer, and we reserve our time to respond to any argument from Wildgrass.
Okay, with that, Mr. Salazar, do you plan on making argument on any of the pending motions or the hearing officer orders?
Yes, I do, Mr. Chair. Thank you very much. I plan on beginning this argument to discuss the motion to dismiss for lack of subject matter jurisdiction. As the commission knows under its Rule 510B, no application may be heard until the applicant has complied with all notice, evidentiary, and all other application requirements set forth in the commission's rules. With that, Rule 506B says the commission shall receive evidence that owners were tendered a good faith reasonable offer to lease or participate no less than 90 days prior to an involuntary pooling hearing. And that's also combined with rules 506C1 and C3, which says that upon a showing by the applicant that it has complied with the commission's rules, the commission may deem an owner to be a non-consenting in the area to be pooled if, and then it says after receiving an offer to participate and given at least 60 days to review the offer, the owner does not elect in writing to consent to participate in the cost of the well concerning which the pooling order is sought. And then the second part is if after receiving a good faith offer to lease and given at least 60 days to review the offer, the unleased owner has failed to accept or refused a reasonable offer to lease. We filed this motion to dismiss because there is evidence demonstrating that there are a number of mineral owners, unleased mineral owners who did not receive the lease offers as required by law. the commission is required to take that evidence to see if indeed extraction has complied with its regulations. The hearing officer indicated in his order that we cannot provide this evidence because this is concerning third-party individuals. However, we've argued, and I think that we heard from the district judge yesterday, that we do have standing to raise these issues. Number one is that we have a substantial relationship with these third parties. We're all being pulled together. Our correlative rights are all subjected to this pooling order. There's economics involved. There's property rights involved. There's due process rights involved. There's a substantial relationship amongst us that allows us to raise these issues on behalf of third parties. And just a little while ago, I submitted to the hearings manager, Mimi Larson, as well as the hearing officer, I submitted to you a 32,000-page document from Extraction. That document pertains to Sheridan South. In that document, if you even just take a look at the first 1,800 pages, which is about 51 owners, out of those 51 owners, only 6 have entered into a lease with Extraction. The other 45, there's no evidence that they received anything at all. As a matter of fact, in the United case, in the 289 case, the evidence shows that there is actual certified tracking of those lease offers to each and every single individual mineral owner. In our case, in 458, there's not even that. There's no tracking, there's no certification, and there's no evidence that these mineral owners have received anything at all. And so the hearing officer's motion or denial of our motion is erroneous. The state of the law is that we can present this evidence to you, and you have to take this evidence. It says you will receive it. And so therefore, because Extraction has not met its burden to demonstrate that that it has met all the application requirements set forth in the commission's rules, under Rule 510B, the commission cannot hear this case. Now, I'm sure Extraction is going to come back and say, well, this Sheridan South information is new to them. But the commission should take note that the Colorado courts have said that we can raise the matter of subject matter jurisdiction at any time. And we can certainly raise it before trial, and we're not at trial yet at 458. And so we are raising this issue as alongside the issues in the United case and 248, whatever case that is. We're raising it alongside of it. And the commission just cannot create jurisdiction on its own. And so we're asking the commission to reverse the hearing officer's denial of the motion to dismiss for lack of subject matter jurisdiction, to accept the evidence that we have presented to this commission, which you have to receive, and to find that this hearing cannot continue because Extraction has not met its evidentiary burden to support that it's complied with all notice, evidentiary, and other application requirements. Thank you, Mr. Chair. And I'm going to reserve the rest of my time for rebuttal.
Mr. Salazar, using how hard it is to find the unmute button. Do the attorneys for Extraction have any response argument on this point?
Yes, Chairman Robbins, we do. I think to begin, there's a fundamental misunderstanding of subject matter jurisdiction here. Subject matter jurisdiction is conferred to the commission by its organic statute by the Colorado Oil and Gas Conservation Commission, which clearly vests this commission with authority over and jurisdiction over all persons and property, and the authorization to issue orders on pooling in these matters. What we're really dealing with here is an issue of an evidentiary burden, which I'll get to in a minute. But there's a couple things that Mr. Salazar citing to. First of all, he's citing to Rule 506. These applications were filed under the prior version of the rules. We should be looking at Rule 530. It doesn't differ substantially, but for purposes of consistency, I think we should be using the old rules. Nevertheless, Mr. Salazar's argument that the commission is required to take evidence, he fails to cite to the pooling statute itself, and that's a really important point because under 116(7)(d)(I), The statute says that the commission shall not enter an order pooling an unleased non-consenting mineral owner under subsection 6 of this section over protest of the owner, unless the commission has received evidence that the unleased mineral owner has been tendered no less than 60 days before the hearing a reasonable offer made in good faith to lease. That's really important here because Mr. Salazar is interpreting Rule 530, Rule 506, and the offer letter is somehow precluding any pooling order from entering in these proceedings. And that's just simply not the case because we're talking about specifically the singular of an unleased mineral owner. We're also not talking about working interest owners, which are also subject to pooling orders. And more importantly here is that the evidence that Mr. Salazar is saying you must receive is when there has been a protest of that owner. We don't have a single protest from any owner in these proceedings, both dockets, alleging that they did not receive a Rule 530 offer letter. If you look at their protests, they're challenging whether or not the lease offers are reasonable, which implies that the Wildgrass protestants themselves did receive the Rule 530 offer letters. Now that is very important. And the reason that's important is because it has to do with standing. Wildgrass is not arguing that these individual protestants did not receive offer letters. They're arguing that these other people out there, which council and Wildgrass do not represent, did not receive an offer. Standing in this to have third-party standing, what they're trying to do here to bring in these arguments about offer letters to other third parties, first requires, and this is in our materials, it's in the hearing officer's order, first requires that these protestants meet the standing requirements, that they have suffered an injury in fact to themselves, a concrete particular injury to themselves. And they've not demonstrated that. In fact, their papers demonstrate the opposite, that they actually did receive these offer letters. It's only then that you even go to this three-part Briggs test about a substantial relationship and the other elements that a party cannot defend their interests. But we don't even have to get there because the Wildgrass protestants have not suffered an injury related to Rule 530 offer letters. They're focused on receipt, and I think this is the other issue here that we're dealing with, is that, and Mr. Salazar brought up the court hearing from yesterday, stating that he interpreted the court as saying that they had standing. Well, that's not true. The court didn't say that at all. What the court did say is that the obligation under the rule and statute for an applicant seeking to pool is to tender an offer to lease to these parties. That is, mail it first class US mail to the last known address of those persons that are entitled to such an offer. And that's under 3460-108 subpart 4. Mailing via US mail does not guarantee receipt. There's nothing in the rules or the statute that guarantee or put an obligation on an applicant to guarantee receipt. And the court even said, the court does not agree that a showing of receipt is required because you can accomplish service of a Rule 530 offer letter by mailing. You do not need to prove receipt. And the materials that Mr. Salazar is relying upon as somehow evidence of non-receipt, what those materials actually show is that Extraction complied with its duty to send the offer letters to these people. Whether they're actually received or not, Extraction can't control that. But deliveries were attempted. The Extraction did tender the offers, and it has satisfied its obligations. I think the other important thing about this third-party standing issue that Wildgrass is trying to assert is they're asserting it over an evidentiary rule. Even Mr. Salazar said, you have to receive evidence on this point. That doesn't implicate subject matter jurisdiction. That is an evidentiary burden related to the commission deeming a party as non-consent. The third-party standing rule applies only in circumstances involving the deprivation of a constitutional right or a challenge to the constitutionality of a statute. We're not dealing with either of those circumstances here. This is simply an evidentiary rule, one that extraction has satisfied, and the materials actually show it. I think at this point, I'd like to just reserve the rest of my time and ask that the commission enter the order as drafted by the hearing officer.
Mr. Salazar, any response?
Yes. So the new rules apply in this case. The commission has been very clear that after January 15th, 2021, that the new rules would apply to any pending application. This obviously is a pending application. Nonetheless, the hearing officer found that 530 and 506 are substantially alike. If you were to believe Extraction's argument, then it would basically render the state statute in your rules superfluous. It would result in absurd results. Number one is, how can anybody, a mineral owner, protest or engage in a protest if they've never received the offer? That's the whole point. And the statute is extremely clear that this commission shall receive this evidence if an individual has received the offer. And it says that the commission shall not enter orders unless there was evidence of that sort. That is further expanded upon by your rules. Your rules where it says no application may be heard until the applicant has complied with all notices, evidentiary, and other application requirements. That notice requirement says that the applicant bears the burden of demonstrating that the owner, after receiving an offer to participate and was given at least 60 days, elects not to participate or fails to accept or refuses a reasonable lease offer. That's what your language says. Now, these individuals, they can't come here and protest because they don't know. And that's not our burden. And it's not theirs either. That's Extraction's burden. By your own language of your rules, that is their burden. And so they can't meet that burden. Now, here they say, here's a little trickery of Mr. Pierce-Chala's argument, as he says, well, you know, we don't have to do any of those things. All we have to do is we just have to submit a certificate of service, and that's all we have to do. Well, if that's true, then why in the United South case or in the United case, why is there tracking on that case? It's because they had to demonstrate, and they knew that they had to demonstrate that those homeowners received those offers. And we have at least 10 individuals where it shows that they didn't receive it. In our case, we don't have any tracking numbers whatsoever. In fact, there's no evidence that anybody received anything. Once again, that's not our burden, and that's not those mineral owners' burden. That's Extraction's burden by the COGCC's rules, by your own language. So Mr. Pierce-Chala is trying to do this little dance around both the statute and the rule. And what he's trying to do is get you to render both the statute and the rule superfluous. And you just can't do that. You don't have that in your authority to do so. This commission shall not enter an order pulling an unleased non-consenting mineral owner, and here we have dozens, if not hundreds, under subsection 5 of this section, over protests of the owner. How are they going to protest if they don't even know about it? We are here protesting, and now we can protest on their behalf. And no, the judge did say yesterday, we have standing to raise this issue before the commission. And I'm happy to provide that transcript to the commission if it is required. Unless the commission has received evidence that the unleased mineral owner has been tendered no less than 60 days before the hearing, a reasonable offer made in good faith. So that's the dual requirement. You will not enter an order unless you receive evidence. And that evidence must come from Extraction. And they can't present that evidence because their own documents. In fact, they don't even contest the documents. It's theirs, right? And so their own documents demonstrate that in the United case, at least 10 people did not receive those offers to lease. And in the Sheridan case, we have right now we have 45 people where there is no evidence that they received anything at all. That's why you can't move forward with this hearing. Once again, 510B, no application may be heard until the applicant has complied with all notice, evidentiary, and other application requirements set forth in the commission's rules. You just can't move forward with this hearing. Extraction has not met its burden.
Thank you, Mr. Salazar. Commissioners, we have now received argument on the motions
May
that,
I have a rebuttal?
sure, make it short.
Yes,
Mr. Chair,
I will
it's
be
my
short.
motion, so if he gets his rebuttal, then I finally I get the.
Mr. Storm, we're not going to take any further argument. Thank you. Okay, commissioners, this is pending before us. And I know that we have Commissioner Nanjapa with us now. Nice to see you, and glad to have you with us. I've got some thoughts on the motions that are before us. My thoughts first revolve around a motion to strike and a motion in limine that the hearing officer did not act on. My thoughts on that, and then I'm going to give you my thoughts on Wildgrass's motion to dismiss. First, with regard to the motion to strike and in limine, I believe that the commission historically has been liberal in regard to what evidence and argument may be presented at hearing. I believe that the commissioners can determine what weight to afford any argument or evidence, and may ultimately determine it deserves no weight, but that it is in the interest of due process and a fully informed commission that the commission generally allows parties substantial freedom in presenting their cases. Additionally, it is difficult to judge whether evidence or testimony should be excluded until the commission hears that evidence in context. So I am generally not in favor of excluding evidence prior to the hearing. Finally, I note that Extraction's motion to strike, motion in limine, was filed on November 8th, a late date where the parties had likely already done significant work to prepare their cases. For these reasons, I will be voting to deny Extraction's motion to strike and motion in limine. And with regard to the hearing officer's order denying Wildgrass's motion to dismiss, at this time, I am not prepared to reach a final conclusion on the hearing officer's order on the motion to dismiss. We have the arguments of parties, but I would like to hear full presentations of the cases in chief before deciding any legal argument. I would recommend to the commission that we proceed with the hearing on both applications, and the commission may make a decision on all legal arguments during deliberation. However, provided the commission agrees that we should deny the motion to strike and in limine, Wildgrass would be able to present evidence and argument on the mineral interest owners who allegedly did not receive offers to lease or participate. So those are my thoughts on the pending motions and on maybe charting a next step that allows for us to proceed into the merits of the case. Do other commissioners have thoughts?
Mr. Chair, could you please repeat the last part about what happens if we do or do not accept in limine?
So I would not deny the motion to strike and in limine, in which Extraction is seeking to get rid of a subset of information that Mr. Salazar and Ms. Merlin desire to present to us. Basically, I would like to have all the doors open. Let's hear all the evidence, and then let's make our legal conclusions at the end once we've heard all of this in context.
Okay, thank you.
Other commissioners with thoughts? Commissioner Gonzalez?
Thanks, Chair. I tend to agree with you. I consider the arguments. I think they're appropriate, and I think it's a sticky part of understanding the entire process of notice that I think is important to this proceeding in general. Therefore, I'm not inclined to move forward with the motion from Extraction, and I'd agree with you on denial of that. I also just given the potential understanding or the potential need for a further understanding of the notice process, what was offered, what was received, and kind of how all that worked out. I also think it's appropriate to wait till the end for our full deliberations to determine if Wildgrass's motion to dismiss is appropriate as well. So I think I'm in line with your thinking there, but I'd vote in favor of denial for Extraction's motion in limine and motion to strike, and reserve, I guess, my decision on Wildgrass's motion to dismiss.
Okay, that's in line with the thoughts that I had, I believe. So, are other commissioners, in line with this thinking as we determine which way to go? Okay, so, AG Davenport, do we need to have a formal motion here?
Thank you, Mr. Chair. I'm happy to be corrected by either the hearing officer or the hearings manager, but my recollection is that there was actually never a hearing officer order on extractions, motion in limine, or motion to strike. And I see hearing officer Peskin just unmuted.
Yes, that is correct, AAG Davenport. Due to the closeness of proximity to the hearing and given the potential prejudice that Wildgrass did not have time to respond, I reserve that for the commission.
Since that is the case, Mr. Chair, I do recommend the commission actually move to deny extractions, motion in limine, and motion to strike, and have a vote on that. I don't believe, since it appears the commission is in agreement not to take additional action on the hearing officer's order dismissing, and since the commission would like to go to hearing on this, I don't believe you need to take any further action, formal action, motion or vote, other than motion and vote in regard to extractions, motion eliminate, motion strike.
Thank you, AAG Davenport. It is certainly handy to have a smart AAG around to help us as we move through these processes. So I believe we're looking for a motion to deny extractions, motion to strike, and or motion and eliminate at this time.
So moved.
Second.
We have a motion and a second. I do not believe there's further discussion. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Okay, that motion carries. We do not believe we need to take any further action on any of the hearing officer orders, and we're going to reserve our final judgment on those things after we've heard from the parties and their witnesses and exhibits, et cetera. So at this time, I believe that we will move forward with each party has 5 minutes for opening, 90 minutes for the case in chief, and 5 minutes for closing. This time is exclusive of commissioner questions. So we will take up opening on docket number 190400289. And I believe we will hear from extraction.
Thank you, commissioners. Good afternoon. Again, my name is Jeffrey Storm, and thank you for your time and attention at this matter this afternoon. Today, we are here for a pooling hearing, and pooling is a very technical term for allocating business risk, costs, and revenues across all parties entitled to share in oil and gas production. But practically, a pooling hearing is a relatively simple process. It requires that the commission evaluate the operator's pre-pooling election letter, which contains both a lease offer and an offer to participate, such to make sure that that offer is reasonable, fair, and compliant with the commission's very straightforward rules. Importantly, pooling is not spacing, pooling is not permitting, it does not cite oil and gas locations. Those issues are handled at different COGCC processes, and accordingly, many of the issues that frequently arise in commission hearings, such as public health, safety, and welfare, should not arise in pooling. This is a different step. In Colorado, pooling is appropriate so long as the operator has satisfied a series of very specific requirements that are imposed by the Conservation Act and by Rule 530, as was in effect at the time of these letters. If the operator has satisfied those requirements, then the operator is entitled to avail themselves of the pooling statute. Broadly, the rules in the Act require that each party be afforded a choice between a reasonable lease offer, a choice to participate in the wells for their proportionate share of drilling and completion costs, or the choice to be statutorily pooled. In today's hearing, you're going to hear testimony that shows that extraction has satisfied those requirements. Specifically, you're going to hear testimony that Extraction has tendered all parties with a reasonable lease offer. A lease offer on terms and conditions commensurate with the prevailing rates in this area, and in fact on terms and conditions that exceed many of the going rates. You're also going to hear testimony that Extraction has furnished all parties with an alternative, that all parties were furnished the opportunity to pay their share of costs in the drilling and completion of the wells that are subject to this rule. And finally, you're going to hear that the elections to participate accurately described the wells, contained a reasonable expected drilling completion and equipping costs, and gave all parties the chance to make a well-informed decision for their interests prior to drilling. You will hear testimony in this hearing that Extraction maintained good faith throughout this entire process, that after receiving protests from the protestants, that Extraction attempted to negotiate the terms of that lease offer that was sent, that throughout Extraction's leasing efforts and terms were consistent with reasonable commercial standards of fair dealing. You will see evidence that Extraction has obtained a significant leasehold position in these lands, and that Extraction's ownership far exceeds the 45% threshold that is required for the board. In summary, you're going to hear substantial evidence from the applicant that they have satisfied the very straightforward rules prescribed for the pooling by the Act and the rules. And all of those activities took place prior. You will also hear testimony from the applicant that the applicant has satisfied all notice and due process requirements that are imposed by the Act and the Commission's rules. That consistent with the Commission's rules, the applicant sent out the copies of the application, the notices of hearing, and all related documents such as maps that informed all applicants, and that they sent those materials out via US mail, perfectly consistent with the requirements of the Act and rules. But in this hearing, you'll also hear testimony from the protestants that goes far outside the typical evidence that you would hear in the pooling. The protestants may argue that the Commission should stray from the straightforward pooling process and read into the rules non-existent illogical requirements such as the following. You will hear from the protestants that pooling cannot occur for this unit because certain owners who have chosen not to protest or otherwise have never participated in this hearing, because that they were not personally served with their election letters, that this pooling can occur. This is not a requirement of the Act. You'll hear a testimony from the protestants that completion operations may have occurred prior to the entry of the pooling order. This is not only untrue, this is further irrelevant to this pooling.
Mr. Storm, I apologize for interrupting, but you have gone past your 5 minutes.
Thank you, Ms. Larson. We'll proceed into the main hearing portion of our presentation.
Thank you very much. Ms. Merlin, I believe you now have 5 minutes and some change to present your opening. You need to unmute.
Let me unmute myself. Okay, thank you. Good afternoon, commissioners. My name is Catherine Merlin. I'm here on behalf of Wildgrass Oil and Gas Committee. I'm here today because in 2019, my client protested having their mineral involuntarily pooled. And I want to acknowledge the reality that Wildgrass members do not want oil and gas development in their community. Oil and gas development, sorry, it exposes them and their families to harmful air pollutants such as the massive benzene spikes that have been recently revealed by air monitoring there. Since this development has begun in Extraction's Broomfield project, much of their fears have been realized, and they and their families have suffered negative impacts to their health, including the Davis 43 site. I'm skipping ahead a little bit, sorry. But we're not here today on a referendum against suburban oil and gas development. Wildgrass members' motive to protect their homes and communities is not more or less relevant to this proceeding than Extraction's profit motive. In fact, between the two parties before you today, the applicant and the protestant, your statutory obligation is to ensure the protection of the protestant, not the applicant. Not only does Extraction as the applicant bear the burden of proof to demonstrate that it has satisfied all the evidentiary requirements for involuntary pooling, meaning that any doubts are resolved in favor of the protestant, but you are also commanded by the legislature to protect the public's interest and to protect them as both mineral owners and as residents. It's no longer the job of the commission to foster industry. That language was deleted in 2019. This is not a complicated puzzle. It's very simple, and it's not punitive to Extraction to require them to follow your own simple rules. When we initially filed this protest of the pooling application in 2019, we raised several issues, including waste, correlative rights, financial instabilities, and other matters. But since then, Extraction has entered and exited bankruptcies, and by shedding $1 billion in debt, they've managed to hang on to their operations. It's clear they're anxious to get new production to market quickly. However, the burden is on the operator to ensure that all unleased mineral owners receive and are given time to consider offers. It's a relatively small burden. Extraction, if permitted to proceed in this matter, will tell you that they've correctly identified all of the mineral owners, named them as interested parties, and mailed them notice to their last known address. In our United South, that was approximately 300 parties, and in Sheridan, it's another 300. In order to even identify all the mineral owners, leased and unleased, a substantial amount of time and effort must go into tracing more than 100 years of mineral rights ownership through a chain of title. In many cases, the minerals have been severed from the surface rights, and leases from half a century ago have to be dusted off and reviewed and then traced through their ownership. So after all of this time and effort is spent, owners are identified, offers are prepared. What is so hard about making sure that these lease offers actually reach the mineral owners? Could it be that Extraction simply doesn't want them to? Lease incentive payments offered are $4,500 per acre with royalties at 20%. Non-consenting, involuntarily pooled owners don't receive these incentive payments. They have to pay statutory penalties and receive only 13% royalties. I am not an investigator and I have never been a landman, but I will tell you that I was able to locate several owners with undelivered offers using Google in about 20 minutes and contact several of them by telephone. These people aren't ghosts, and Extraction is capable of ensuring delivery of the lease offers if they wanted to. We filed a protest in 2019. Extraction has had plenty of time to dot their I's and cross their T's. We filed a motion on these very grounds back in September. They have had plenty of opportunity to correct their errors. In fact, Mr. Rayburn's affidavit doesn't even claim that all owners received their offers. We have evidence to the contrary, in fact. Wiregrass has presented significant evidence to the hearing officer, and we will present evidence to you today based on Extraction's own disclosures that numerous unleased mineral owners did not receive offers to lease their mineral. I'll skip through all the names of the people. Let's see. So we also found 2 owners in addition, the Larry Womble Revocable Trust, as well as the Natalie Quarantino Revocable Trust, for whom Extraction did not provide any evidence of a lease offer having even been drafted. Neither a copy of the lease offer, nor a signed lease, nor a tracking number. I spoke with Natalie yesterday, and she had no recollection of an offer and had no idea this hearing was even proceeding. Wiregrass does not represent these owners. We aren't raising claims on their behalf. Extraction has the entire burden of proof in this proceeding. The Commission Rule 506B says that the Commission will receive evidence that owners were tendered a good faith reasonable offer to lease, and 506C further states upon a showing by the applicant that it has complied with the rules, the Commission may deem an owner to be non-consenting if after receiving an offer to participate, the owner does not elect in writing to consent. I see that I'm at time. I will present the evidence to you in the case in chief, but I will remind you that it is not our burden to present this evidence. It is Extraction's. Thank you.
Thank you, Ms. Merlin. Okay, at this time, I believe Extraction will proceed with their case in chief. Mr. Storm, do you want to call your first witness?
Yes, thank you, Mr. Robbins. If you'll give me just a moment, and we will share our screen so that we can have our exhibits on hand here.
Mr. Chair,
Yeah, AG Davenport.
thank you. Whenever it's appropriate, we will need to swear in witnesses.
Thank you for that, Davenport. Now let's one of two ways can happen here, Mr. Storm. If you have all of your witnesses available now, we can swear them in one fell swoop. Or if not, we'll do them one at a time. Your call.
I think we're happy to have our witnesses sworn in one fell swoop. We have one witness appearing telephonically, Mr. Nathan Bennett. So as long as he's present at this moment, then we're happy to do it in one sworn.
Ms. Larson, can you bring Mr. Bennett to the panel?
Yes, he's being brought in right now.
I would like to raise and preserve an objection to this demonstrative exhibit, as I believe it does not completely state the requirements of the Act N530 as it states in the title of this slide.
Okay. So noted. Do we have Mr. Bennett? I think I see him at the bottom of the screen. He needs to unmute. AG Davenport, do you want to swear in the witnesses?
Sure. Thank you, Chair. Mr. Bennett, we'll start with you. Would you raise your hand and simply state your name and say that you swear to tell the truth?
Jason Bennett, I swear to tell the truth.
Thank you, sir. Mr. Storm, any other witnesses?
Yes, Jason Rayburn.
All right, Mr. Rayburn.
Right.
I'm sorry, Mr. Chair, I didn't catch that.
I think Mr. Rayburn's in the room there.
Yeah. Mr. Rayburn, would you do the same, please? Raise your hand, state your name, and say that you swear to tell the truth.
My name is Jason Rayburn. I swear to tell the truth.
Thank you.
Okay, Mr. Storm, who are you calling first?
Yes, we'd like to call Mr. Jason Rayburn, landing for extraction.
Okay. And you're on the clock now. You've got 90 minutes for your presentation, and Ms. Larson will be keeping track. And that's outside of questions from commission.
Thank you very much, Chairman Robbins. Thank you. Mr. Rayburn, could you please state your name and your position with extraction?
Jason Rayburn, landman for extraction oil and gas.
And can you please describe your experience as a landman for extraction and your experience in the DJ Basin?
I've been a landman for over 15 years, 11 of those years here in the DJ Basin. For extraction and this project specifically, I've overseen the wells planned, drilled, and pooled with the Oil and Gas Commission.
And have you overseen land matters and functions related to this application, docket number 190600458 at all, but more specifically this unit being the Sheridan?
Yes, I've supervised the initial planning, lease acquisition, the broker who managed the broker who distributed those lease offers and well proposals throughout the pooling proceedings.
Okay. And Mr. Rayburn, what is your educational background?
I have a bachelor's in business administration from the University of Oklahoma, majoring in energy management.
And do you have any advanced certifications in energy management?
I have my professional certification from the American Association of Petroleum Landmen.
And do you have any, have you received any awards from that organization or other certifications?
I was recognized as Landman of the Year by our local Denver Landman Association in 2018.
And Mr. Rayburn, do you have expertise in and knowledge in the rules and regulations of the Colorado Oil and Gas Conservation Commission?
Yes, over the years, I've been part of testimony for pooling. I'm familiar with the rules and elections and well proposals sent.
Are you familiar with Rule 530 as it existed when these election letters went out and the Oil and Gas Conservation?
Yes.
And are you familiar with Extraction's standards of dealing in its lease negotiations in this unit? Extraction's lease strategy, Extraction's negotiations with mineral owners in the application lands, any of those matters that may have governed land functions related to this unit?
Yes, I've supervised leasing efforts and handled lease negotiations and well proposals associated with the project.
Do you have, do do you have knowledge, expertise in oil and gas lease terms, the granting clause, service use provisions, terms that commonly occur within oil and gas leases?
Yes, these are commonly used terms, and I've negotiated or reviewed leases having similar terms across the basin.
Okay. And do you have knowledge and expertise and training in preparing election letters under Rule 530?
Yes, working as an operational landman over the years, sending out well proposals along with the drilling and completion costs noted on AFEs. I've also worked as a non-operated landman, receiving such well proposals and AFEs to determine the participation in such projects.
So you're familiar with AFE and development costs across the basin, both for extraction and other operators?
Yes.
Are you familiar with the typical drilling and completion costs in an AFE set pursuant to Rule 530?
Yes.
Well, then, Commissioner, I'd just like to certify Mr. Rayburn as an expert land witness, qualified to testify as to the reasonableness of extractions lease offers, prevalence of lease terms, whether certain oil and gas terms are industry standard and customary in the business, reasonableness of AFE costs, and other land-related issues related to the claims raised in these matters.
Ms. Merlin, any objection?
I have no objection to his qualifications as an expert witness in those limited areas. Thank you.
Okay, he is certified. Continue.
Mr. Rayburn, I'd now like to move to the application. Are you familiar with this exhibit?
Yes, this is an outline of our United South unit. It's comprised of sections 9 and 16 in Township 1 South, Range 68 West.
Okay. And if I could have this, this slide number 5 from the presentation admitted as an exhibit, exhibit number 22. Mr. Rayburn, how many acres does extraction own within this area that's described here?
We have 982 acres.
Okay. And what is extraction's working interest in this unit?
77.5%.
And what is the total working interest percentage of consenting ownership within this unit?
We have just over 81% consenting working interest.
Thank you. And have you reviewed title documents covering this unit, covering the ownership interest in this unit?
Yes.
And are Mr. Rayburn, is it your testimony that extraction has obtained the consent of or holds more than 45% of the working interest within this unit?
Yes, we do have more than 45% working interest.
Now, Mr. Rayburn, I'd like to move to Rule 530. If we can keep going here. First, can you describe the history of extraction's leasing efforts of acquiring those leases you just described?
We utilize a third-party broker service that employs landmen with specialized title experience to review title documents, chain those title documents, conveyances to determine current ownership. In United, we began making lease offers in 2016 through 2019. And these efforts yielded numerous leases within this unit, but there still remain unleased owners.
Okay. And so as you describe it, landmen review the public documents. Is this correct?
Yes.
And those public documents contribute to the interested parties list that is dictated by the commission rules. Is that accurate?
Yes.
Okay. And is that the addresses that you use when you mail notice to those parties? Does extraction take that address information from those public title documents?
Yes, we use the last known address in the public records.
And in your experience, is that consistent with the commission rules and industry practice and custom in pooling applications?
Yes.
Mr. Rayburn, now I'd like to go to the exhibit number 1. Do you recognize this exhibit?
Yes, this is the election letter for Michael and Amber Mccord.
After the leasing efforts, did extraction obtain leases covering 100% of the working interest?
We were not able to secure leases from 100% of the owners.
Okay, so if you have less than 100%, what are the next steps in the approval process?
We send out an election letter, such as this one, that gives the options, that an unleased owner has to either lease or participate as a partner in the well.
And you said this is the election letter that went to Michael and Amber Mccord. Is an election letter in the same form tendered to all unleased mineral owners?
Yes.
And where is that offer letter tendered?
To the last known address that was found in the public records during the ownership search.
Mr. Chair, can I ask a question? Is there an election letter that you're wanting us to see on the screen? Because I'm still seeing the spacing unit.
Thank you, Commissioner Messner. If we could have our time pause.
It's paused.
Stop. Thank you, commissioners. And again, thank you for bearing with us. If you'll just allow us a little bit of leeway while we kind of navigate through this electronic here. So, Mr. Abrams, as you said, you're familiar with this exhibit?
Yes.
And would you please just restate that testimony that regarding this election letter? Was this form tendered to all working interest owners within the?
Yes, it's sent to all working interest owners and unleased owners to give them the option to participate. It also outlines the option to lease with the lease terms contained therein.
Okay. And are you familiar with the notice requirements of the Oil and Gas Act?
Yes.
Are you aware that the Act provides that notices are to be sent via U.S. mail to the last known address of the parties to be pooled?
That's correct.
Okay. And how were the election letters within this unit tendered / furnished to the owners?
We did send them via USPS mail. We did delivery confirmation with tracking.
Okay. And to what addresses again?
To the last address known of record from the title documents.
And were the addresses identified by your brokers? You just said, were those the same addresses which were later provided for purposes of notice of this pooling application?
Yes, they're the same addresses.
And quickly, commissioners, I'd like to request that this exhibit 1 be admitted into evidence. And I would like to pull up these seconds.
So we'll consider it admitted. Ms. Merlin, if you ever have objections to any exhibit, let me know, but otherwise I'm just keep this moving. I'm just going to admit.
No objection to this exhibit.
And quickly, commissioners, are you able to see the screen now? It should be an Excel table showing exhibit 15.
We can see the screen, but my old eyes can't read it. It's too small.
That's fine. We can zoom into that. Mr. Rayburn, are you familiar with this exhibit?
Yes.
And can you please describe this exhibit?
This exhibit shows the individuals or parties. At the top in blue are working interest owners who received elections to participate. The second half are unleased owners that received the election to participate or offer to lease.
And is it your testimony that each one of these owners received an election letter in the method you just previously described?
Yes, they did.
Okay. And is that practice, again, consistent with commission rules and industry practice at the time?
It is consistent.
I would like to go to one more exhibit, Mr. Rayburn. And Are you familiar, Mr. Raver, with these documents?
Yes, this is the application for pooling.
Zoom in because our eyes are a little bit smaller here. And so are you familiar then with this exhibit? The notice of hearing?
Yes.
And when this notice of hearing is sent out, are you familiar that that process is handled by the commission and the attorneys that practice before the commission?
Yes, the addresses provided are consistent, or the exact same addresses that we utilize from the county records to send out well proposals and lease offers.
And commissioners, I just like for exhibit 15 and exhibit 13 to be admitted into evidence. So, Mr. Raymond, I'd like to go back to the election letter. And I will move through it as you direct me. So what is the date of the election letter?
It's dated December 27th, 2018.
And when was this election letter tendered?
December 28th, 2018.
Okay. And are you confident of that date?
Yes, we were able to find correspondence with my broker that stated and confirms that went out December 28th, 2018.
And is that more than 60 days before the hearing for this matter?
Yes.
And does this election letter contain an offer to lease and an offer to participate?
Yes, if you go to the next page, it's got the details outlining the lease terms being offered.
Okay.
At the page 1, it also outlines the owner's percentage in the well, I'm sorry, just above there.
Sure. And we can get into the details in a
Okay.
little bit here. That's just fine. So, and it also contains an offer to participate, is that correct?
Right.
Okay. And where is that?
If you continue down, these are the options to participate with their interests, to not participate, or the third option to participate and pick up any non-consent interests.
And did this election letter include a copy of COGCC's pooling brochure?
Yes, it does.
And where is that?
If you continue down after the AFEs, we provide a copy of the commission authored document regarding pooling.
Okay. And does that describe the pooling process? What does that do?
It does describe the pooling process. It describes why pooling is necessary and what to expect from pooling.
And did this election letter contain contact information for an extraction representative to handle calls?
Yes, it's got our broker information listed just below, or excuse me, above the signature block on the second page there.
And did the election letter afford at least 35 days written notice?
Yes, it actually states 60 days, which is more than was required at the time.
Thank you. So now I'd like to look at the lease offer that's located within this election letter. Can you please describe the terms contained in the lease offer that's on the document?
Certainly, we offered a no surface occupancy lease that essentially means that no drilling operations would occur on the leased premises that we are seeking to lease. We offered $4,500 per acre as a bonus. The term is 3 years and the royalty is 20%.
And were the other terms of this lease offer more or less favorable than the other terms?
I would say they're competitive, if not more favorable, and that's indicated by our ability to obtain numerous leases, even though we did have competition from other parties seeking to lease the same interests.
Is that a copy of the oil and gas lease itself?
Yes.
Were any of the terms in this lease intended to defraud or seek an unconscionable advantage over any other?
No.
And what is your state of mind when you're preparing this lease offer? What is your goal?
Our goal is to ensure that we are offering a fair and competitive lease. We also work to ensure that the mineral owners who are being offered the leases understand what's in the lease. And that is done by providing contact information for either myself or in this case, our broker, the representative, to understand the project, exactly what the lease means.
And did you maintain this state of mind throughout the pre-preliminary process?
Yes, we did.
And was that consistent with, in your experience, is that consistent with commercial standards?
Yes, they are.
Was this lease offer reasonable and consistent with prevailing rates in the area?
Yes, this is not the first leasing effort that we did in the area. We have multiple other units here. And since this was not the first one, we were able to go off of previous leasing efforts to determine from what we thought was a reasonable offer based on our previous leasing efforts and also the other competitors.
Now, I'd like to discuss another part of the offer to participate. And are you familiar with the requirements of Rule 530 as they applied at the time?
Yes.
Okay. And so we're going to go through some of the requirements for that rule. Can you point me to the estimated spud date that is in this lease offer?
Here in about, let's see, if you go back up a bit there, the anticipated spud date is third quarter of 2019.
Okay. Can you point me to the location and objective depth?
I believe it's the fourth page. This outlines the location.
If I may interject with a brief objection, Rule 530 is no longer in effect. The appropriate citation is to Rule 506.
Mr. Storm?
I mean, the Colorado law assumes that the rules are to apply prospectively. SB 19-181 applies to these proceedings. The hearing officer has weighed in on that, but the hearing officer has stated that the effect of SB 181 is simply to apply good faith requirements and a 45% ownership requirement to the lease offer. The hearing officer has not stated that it is Rule 506 for purposes of some orders. The hearing officer has said that he would be using references to Rule 506. And for that, I need to look to Miller, the United States, 294 US 435. Which provides that generally administrative regulation may not be construed to operate retrospectively unless intention to that effect unequivocally appears, particularly where an obligation is created. I would also cite to EchoSite LLC, v. County of Pueblo, 431 F sub 3rd 1231, providing that as a general rule, legislative enactments and newly promulgated agency rules, due to their affinity to legislation, are given only prospective effect, whereas judicial decisions may also be given retroactive effect. I would finally point to Denise v. Robles v. Lynch, 803 F 3rd 1165 at 1168, 10th Circuit 2015. A statute, order, or edict operates retroactively when it seeks to impose new legal consequences to events completed before its announcement. I think that is persuasive authority here, considering that the rules provided very specific requirements. The election letters were tendered at the time when the rules were in effect. The rules have undergone substantial change, and though time has passed, the election letters were completely in compliance with the rules in effect at the time.
Thank you both. I'm going to overrule the objection and indicate that reliance on old Rule 530 does make sense for this older application. I would note for the record that there's, in my opinion, no real substantive difference that I can think of between old 530 and current Rule 506. With that said, please move forward with your witness.
Thank you, Chairman Robbins. Can you please locate the location and objective depth of the well south of the pool?
Certainly. So this table states the target formation for each well. It also shows with footages the surface location, landing point or heel of the well, and the bottom hole location. It also provides the total vertical depth, which is measured from the surface to the final vertical point portion of the wellbore, and then the target measured depth is essentially a combination of the vertical depth and horizontal portion of the wellbore, giving it full measurement of the wellbore.
Okay. And what is that? I see FEL, FWL. What are those references to?
Those reference the location of the wellbore from either the FNL is from north line or east line, west line, south line, depending on which portion of the section the well is located, and also based on its orientation.
And why was the location of the well described in that way?
This is how wells were previously described under Rule 318A.
And is that industry custom and standard at the time of the selection?
Yes, it is.
And you stated the formation. What is the objective depth of the well?
We've placed on here for Niobrara wells are 8,000 feet, and for Codell wells are 8,300 feet.
But then you also put these columns TVD and target TMD. What are those references to?
The vertical depth is the vertical portion of the well from the surface down to the point where the well curves into its horizontal position. And the target measured depth is the full length of the lateral from surface to bottom hole.
And were those terms provided for under Rule 5? They were defined. Were those rules terms defined under Rule 530 starting later? But were those discernible by looking at the commission rules? Those terms.
Yes.
Was this description provided for all 16 wells subject to pooling under this application?
Yes.
Mr. Raymond, can you point to me the estimated drilling and completion costs for these wells?
Yes, it's located on each AFE that is located in the well proposal, which states the well name at the top, the Northwest B S1620-01C, and the estimated AFE amount is $5,388,673.
Okay. And Commission, if Ms. Merlin has no objection, I would just like to request that the Commission take notice that this was provided for all 16 wells rather than going through each AFE if it is accepted.
That's fine with me as chair. I don't need to go through all 60, and we'll take judicial notice of that fact.
And can you,
So just ask one question. So you said you wanted judicial notice taken that this was the same for all 60 wells? Not an allegation that every mineral owner received this. Sorry if I'm.
So every mineral owner did, every unleased mineral owner did receive this as standard practice. This is the same format that the AFEs are presented. If you go through the exhibits with the well name and the estimated costs associated with each individual well.
Right, I will just preserve an objection. We have no objection to agreeing that this was contained in every lease offer that was in fact tendered. However, we object to any argument that this was in fact received by all unleased mineral owners.
Okay, we will preserve that point, Ms. Merlin. And Mr. Storm, we will note the point that you've made here so that we don't have to do this 60 times.
Excellent. Thank you, Chairman Robbins. So Mr. Rickard, can you please identify the owner's portion of the cost to be borne?
Within the letter of the lease offer, it does state their estimated share of the well costs for each well by taking the percentage stated in the letter and applying that to each AFE that we just reviewed.
Okay. And are you aware that, Mr. Rickard, that current Rule 506 requires that costs be specified as a dollar figure?
That is the current rule, yes.
Okay. And was that done here?
No, because at the time, the requirement was only that a percentage be furnished within the well proposal.
Okay, thank you. Mr. Rickard, is there any requirement in the rules or the act, either currently or at the time of the election letters, which requires that they contain costs for plugging and abandonment or public health, safety, welfare costs?
No, there is no requirement for that to be included.
And Mr. Rickard, since elections were tendered, has anything occurred to lower prices or development costs since that time? What has the well done since that time?
Since the proposals, commodity prices have gone up, but also because of our the size of our development here, the actual costs of developing each well have gone down, and that is due to improved learnings from previous wells drilled. We were able to apply that to wells drilled later, and also increase knowledge of the area and drilling techniques.
Thank you. And so if a party made an election at that time, has anything happened that would result in that election being unjust, unreasonable, or prohibitive to them obtaining their just and equitable share?
No.
Have any parties asked to change their election?
No, we've had no parties asked to change their election.
And in your experience as a layman, does the spud date commonly change for projects?
The spud date is anticipated based on our drilling schedule at the time of the well proposals and lease offers going out. That date, of course, can change due to a number of factors. It could be a regulatory issue, it could be rig availability, it could be some other issue that comes up during our development timeline that would cause the spud date to move up or down on our schedule.
And is there any requirement in the rules that would require that elections need to be recent in the event the spud date changes?
There's no such requirement.
In your experience, is the information in this election letter commonly used in the industry and accepted by the commission at the time for Rule 530?
Yes, they are.
And in your experience, are the costs identified previously on each authority for expenditure, are those reasonable?
Yes, they are.
Mr. River, is it your opinion that all unleased mineral owners, including the contestants, have been furnished the information required under Rule 530 of the Act?
Yes, they've all been furnished.
Objection. The definition, the definition of what does furnished mean? Sorry.
That's if we could stop time.
Actually, Mr. Storm, I'm going to overrule the objection. The commissioners will understand or not. You just keep moving with your witness. Thank you.
Thank you, Chairman Robbins. Right, Mr. Reagan, I'd now like to look to the lease offer portion of the election letter. Are you familiar that the Act requires a good faith offer?
Yes.
Okay. And in your experience in this process, are you in constant communication with your brokerage agent?
Yes, we are.
And in this unit, if a lessor wishes to negotiate certain terms within the lease, is extraction open to negotiation of such terms?
We are open to negotiation of terms in the lease. And we provide contact information, email address, and phone numbers so that mineral owners can reach out to us.
Okay, have you personally negotiated and resolved lease protests through negotiation?
Yes, typically, if we receive a protest, we're able to address the mineral owner's concerns, answer their questions, and resolve their concerns and issues.
Did the protestants or their counsel ever reach out to you in an attempt to negotiate the terms of the lease offer?
They did not.
But you're familiar that the protestants claim that they've never received a reasonable lease offer, correct?
Yes.
And are you familiar that their protest states that several specific terms are unreasonable under the oil and gas lease?
Yes. A lot of their terms that they deem unreasonable are common in oil and gas leases across the basin.
Mr. Rayburn, are you familiar with this exhibit?
Yes.
And can you please describe what this exhibit is?
This is a communication from our council to the protesters' council, requesting clarification on their objections. And also, it's my knowledge that we reached out in order to negotiate these terms, but we did not hear back.
And to your knowledge, the protestants never responded to this attempt to negotiate the lease.
That's right.
Okay. Did they ever otherwise contact you about negotiations of their lease offer in any way?
No.
Okay, thank you.
Objection. This email is labeled from Jeffrey Storm to Joe Salazar. It is not addressed towards me. It is not relevant to this proceeding. Oh, sorry. Wait, I'm looking at the wrong correspondence. Never mind. Forget that objection. Sorry.
And commissioners, I would move to admit this is exhibit number 7 into evidence.
So admitted.
Mr. Rayburn, you stated before that you're familiar with the act and the rules, specifically Rule 530.
Yes.
I would like to go to another exhibit 18. And commissioners, can this exhibit be seen by the commission?
I think we're still seeing exhibit 7.
Okay. Just one moment and we will get it moved over. And Mr. Rayburn, are you familiar with the commission's categories of determining reasonableness under Rule 530?
Yes.
And you oversaw and have since reviewed the lease offers as well as the protests that were raised by the protestants.
Yes, I have.
And you're familiar with the rates and terms within the United South unit that were offered to all owners. Is that correct? That was prior testimony?
Yes.
Can you please quickly re-summarize the principal terms contained in the offer that was described as Exhibit 1?
Each offer contained a no surface occupancy provision. The offer was made for $4,500 per net mineral acre with a 3-year term and a 20% landowner royalty.
And Mr. Rayburn, are you familiar with this exhibit number 18?
Is that this version?
Yes.
Yes. Yeah.
And did you prepare this document?
I did prepare this document.
And can you please explain what this document shows?
This is a summary of leases contained within the unit. We detailed the lease date, annual rental, bonus amounts, the royalty, and other terms that are common within the oil and gas leases.
So now we'll be referring to this exhibit number 18, but In all questions, we're talking about exhibit number 1 that we've identified previously. Mr. Rager, what was the proposed annual rental per acre in the election letter that was previously shown?
The lease is paid up, so there's no annual rental for the lessee not producing or developing the lease. Instead, we provide a bonus per net mineral acre.
And is that common and an industry standard term in this unit?
Yes, and that is common in the majority of modern day oil and gas leases.
Is it prevailing with current rates in the area?
Yes, it is.
Mr. Rayburn, are you familiar that WOGC objects to the granting clause of the lease?
Yes.
Are you familiar with the fact that they claim that it's unreasonable because it covers coal bed methane?
Yes, and the lease form is extraction standard lease form, and so that's contained within all of our leases. But we have stricken that where owners have requested, as that is not our target here in the area, but again, it's part of our standard lease form, and we're happy to strike it when requested.
And so was that one of the terms that you were willing to negotiate with the contestants?
Yes.
And they, is it correct that they did not respond to that request?
Correct.
Mr. Rayburn, are you familiar that the surface use clause is one that Wildgrass alleges to be unreasonable?
Yes.
Is that true?
No, the ingress egress is used in the majority of oil and gas leases, but again, this no surface occupancy was included in the initial offer, given we had already identified our surface location to give the mineral owners an indication that no drilling operations would occur on the lease premises.
Okay, thank you. Are you familiar that WOGC alleges continuous production is unreasonable in certain respects?
Yes.
Okay, and can you please explain to the commission what a continuous production clause is? Their understanding.
Sure. After the conclusion of the primary term, if the operator plugs the last producing well on lease, this provision allows them to reestablish production by drilling a new well to maintain the lease and establish production.
Okay. And is a continuous operation clause or a cessation clause, is that reasonable?
It is the purpose of the continuous operations clause. It allows the operator to continue operating wells to establish production if they are engaged in these activities over the expiration of the primary term.
Okay. And are you familiar offhand how many of the leases within this unit contain continuous production or cessation clauses?
There are 229 of the 487 leases.
And how many of the leases contain cessation or continuous production clauses of any duration?
All of the leases contain that provision.
And is it your opinion that the continuous operations clause is reasonable?
Yes.
Are you familiar with the fact that Wildgrass alleges that the lease is unreasonable because it does not terminate if compliance is prevented by law, order, or regulation?
Correct.
And can you explain that clause, please?
The force majeure clause is in our lease to stop the clock on the primary term if the operator encounters issues that are outside of their control that would prevent them from developing the lease.
And our force majeure clause is reasonable and standard within oil and gas leases?
Yes, and they are present in the majority of the leases in the unit.
Are you familiar that WOGC alleges that the shut-in clause is unreasonable?
Yes.
Can you please explain that to me?
The shut-in clause is utilized for a number of different things. It may be that the operator is not able to obtain a sufficient market for product, which means the pipeline may be at capacity, and so there's no way to produce hydrocarbons into that pipeline. There's also the shut-in provision for the operator to go in and do work on a well. If something should break, then it allows time for the operator to shut down production for the time allotted within the lease, fix the well, and then reestablish production. Wells are also shut in when offsetting wells are being fracked to protect the well bore.
And is it, how many clauses or how many leases have shut-in clauses?
All of the leases have shut-in clauses.
And is it your opinion that the shut-in clause is reasonable in this instance?
It is reasonable.
Are you familiar with the fact that Wildgrass alleges that Extraction's proposed 20% royalty is unreasonable?
Yes.
And is that true?
Not from what we've examined with the overall leases in the unit. The average lease in this unit has a 17.5% royalty. Again, we based our offers on prevailing lease rates in the area, and that rate seemed competitive.
And are you familiar with what the average lease royalty amongst kind of recent leases is?
For this unit?
Yes.
The most recent leases that we've taken in that time frame mentioned from 2016 on is about 19%.
Thank you. And are you familiar with the fact that Wildgrass alleges that royalty deductions are unreasonable for Extractions in the South?
Yes, I understand it's in their objection.
Okay, can you please explain royalty deductions in a lease?
Historically, royalty deductions have been commonly incurred by mineral owners. The deductions include gathering, processing, treating, and or transportation costs.
And did Extraction offer to negotiate the lease by striking the deductions clause?
We did make that offer.
Are you familiar with the warranty of title and the fact that Wildgrass alleges that clause in Extraction's lease is unreasonable?
Yes.
Can you please explain what the warranty of title is?
This provision essentially states that the lessor warrants and defends that they are the owner of the property.
And is warranty of title customary and reasonable in this area?
Yes, and it is present in a prevailing number of leases within this unit.
And then lastly, are you familiar with the fact that Wildgrass alleges that several other clauses, water use, litigation, right of first refusal, that they allege these clauses are unreasonable?
Yes, but they are all commonly used terms that have been accepted in a prevailing number of leases within our unit.
Mr. Rayburn, do you consider this a good, fair offer based on your experience?
I do believe it's a good, fair offer, again, based on what we've seen in the area in terms of competing offers and lease forms and terms. Also, the fact that we were able to obtain a significant number of leases under our terms with the presence of numerous other competitors leasing at the same time in the area.
And are the terms any less favorable than the terms currently prevailing in the area?
No, they're not.
Is the protestant's offer reasonable?
Yes, it is.
We discussed.
I would object that's an ultimate conclusion. Sorry.
Mr. Rayburn's already been certified as an expert witness, able to opine on whether or not lease terms are least reasonable and consistent and prevailing within the lease rates in the area. He's simply providing his expert opinion.
I believe that reasonableness is a legal conclusion, and he has not been certified as an attorney or a judge.
I'll,
I'll withdraw the question.
okay. Keep going.
I'm not going to withdraw the question. I'll restate the question. Is the protestant's offer reasonable?
Yes, it's reasonable.
Same objection.
At any point throughout the proceeding, have the protestants responded to attempts to negotiate a lease?
They did not respond.
So far as you know, have they reached out to your counsel to negotiate a lease?
Not that I know of.
Have the protestants or protestants counsel reach out to you personally to respond?
No, they have not.
And is it your testimony that the protestants have been tendered and refused a reasonable lease offer?
Yes.
Was that lease offer made in good faith?
Yes, it was.
And was it on terms any less favorable than those prevailing in the area at the time the application was
No, they were not.
made? Have all owners in this unit received timely notice of the application?
Yes, they have.
Was that notice tendered pursuant to the commission's rules?
Yes, it was.
Were all owners tendered and furnished with the information required by Rule 530 as in effect at the time?
Yes, they were.
And is it your testimony that this matter is eligible to be cooled?
Yes, it is.
I would object to that last question as a conclusion of law as well.
Objection overruled. We will be making the ultimate determinations, and so I think that the commissioners can understand that this is a opinion from a witness. Mr. Storm, any further questions?
If Commissioner Robbins, if you will simply allow me 1 minute to confer with counsel, and then we will notify the commission. Thank you, commissioners, for your time. We have no further questions. And we'd like to reserve the rest of our time for rebuttal.
Okay, Ms. Merlin, you have an opportunity for cross, understanding that you have 90 minutes all in, and we will keep track of the time you allocate for cross here.
Thank you, Chair Robbins. I will try to keep this brief. Mr. Rayburn, did extraction disclose any lease information on cornering and contiguous units for the commission to consider the reasonableness of lease offers?
Yeah.
Sorry?
Are we on mute?
Just. No, we're not.
That was a no.
Okay. Exhibit 2, let's see if I have screen sharing capabilities. I'm sorry. Okay, you're still screen sharing, and so I'm not able to while you are screen sharing.
Yeah, Mr. Storm, if you could stop the share, then we'll get Ms. Merlin an ability to share. And hold the time, Ms. Larson. Okay, Ms. Merlin, let's see if you can share.
Thank you very much. Mr. Rayburn, can you see this exhibit?
Yes.
Is this Extraction's original application in this matter? Show
Yes.
you the signature and the date.
Yes, it appears so.
And this is your land testimony followed by exhibit 1, which is a map of the units, and Exhibit 2, which is a list of the leases. I have highlighted this as a demonstrative exhibit. I will note that these highlights do not appear in the original exhibit. But other than the highlights, you would agree that this is a true and accurate copy of the interested parties that was filed with this original application.
Right. So the application would include every owner, regardless of whether they are leased, unleased, or working interest party.
Correct. And this document shows, in fact, the ownership type. The first 7 interested parties are listed here as working interest owners, followed by 35 unleased owners. Is it true that approximately 35 interested parties were unleased mineral owners as indicated by this exhibit?
I haven't had the count, but yes, anybody indicated on here as unleased would have that designation.
These are the unleased owners sought to be force pooled in this proceeding.
That is correct. However, we do have Larry Wombolt is participating as a partner in the well.
Thank
Is the
you.
only distinction that I can make from this.
That was going to be my next question, whether any of these owners have executed leases since the time this application was filed. Have any other owners executed leases since the time this application was filed?
I'll have to look at my spreadsheet to look at lease dates, but off the top of my head, no.
Okay. Extraction disclosed as part of the pre-hearing proceedings, the files containing all the lease offers that were made to the unleased mineral owners in this unit. Isn't that true?
Yes.
And did Extraction withhold relevant documents from disclosure?
No.
Isn't it true that in your disclosures, you did not provide a lease offer for the for the Natalie A. Quarantino Revocable Trust?
I don't know that off the top of my head without reviewing the documents.
Okay, can we provide Mr. Rayburn a moment to review the documents?
Mr. Storm, do you have the relevant documents there for the witness to review?
Real quick, is Miss Merlin, are you referring to the Natalie A. Quarantino Revocable Trust? Is that the party that we're referencing?
Yes, and it's, sorry, for the record, it's Ms. Merlin. I'm married.
I apologize. Is that, so it's the Natalie A. Quarantino Revocable Trust, that's the party's interest that we're referencing?
That was my question, whether no lease offer was disclosed.
Yeah, then I would object. That's an irrelevant, it's irrelevant to this hearing. The Natalie A. Quarantino Revocable Trust is not a party represented by Ms. Merlin. It is not named as an exhibit, but Mr. Rayburn has already testified to the fact that all unleased mineral owners received offers to lease and or participate. This trust has also further not protested this hearing. They have not appeared or otherwise objected. It's simply irrelevant to this line of question.
Well, I understand you don't want this evidence introduced. However, I would make legal arguments with the permission of the commission regarding the admissibility of evidence if they so desire. I will point out that in administrative proceedings, the rules of evidence are typically followed, the Colorado rules of evidence, except that they may be relaxed. Since the normal rules of evidence would permit me to present this evidence as relevant to the question of whether Extraction has met its burden to show that it has provided lease offers to all unleased mineral owners, I would suggest that the evidence should be admissible here.
And I'm going to rule that the evidence is admissible, and then the commissioners will weigh the evidence in deliberation. So let's proceed forward. I'm still not sure if the witness has the relevant information to look at to be able to answer the question. Normally, cross-examination counsel would need to be providing that information so that he could look at it. I think she's asking Mr. Storm if they've got that information themselves.
Mr. Roberts, if I could just provide some color, again, it was not, that evidence was not provided as extraction's case in chief. There was narrative testimony provided as evidence that that an election letter in the form that was identified as Exhibit 1 was provided to all unleased mineral owners. The trust identified by Ms. Merlin is one of the unleased mineral owners to whom Mr. Rayburn testified received an election, but we do not have that document. It's not typically or custom with the commission to request examination of every lease offer that went out with the unit. It's not part of our.
Okay, and that's fine. And Ms. Merlin, I'm going to allow the line of questioning, but I do think it is incumbent upon you to have relevant documents so that the witness can answer your questions.
Thank you, Mr. Robbins, Chair Robbins. I do appreciate that. This particular piece of evidence is somewhat difficult. I do have the documents that were provided by Extraction as part of their disclosures, which included lease offers to approximately 35 unleased mineral owners. This was not among them. This lease offer was not among them. So it's actually a negative. It's an absence of evidence here, and it's difficult to, but I will move it along. Sorry.
Ms. Merlin, I think Mr. Rayburn would like to answer the question.
Oh, thank you. Please do so, sir.
I have a tracking spreadsheet that shows the trust in question was sent an offer. I have the tracking number, and I also have the receipt date for this party. The receipt date was January 10th of 2019.
All right. Well, that's.
So let me ask a follow-up question. So when you say the receipt date, is that some form of certification that the trust received the offer?
That's correct.
Okay. Okay, Ms.
Sorry.
Merlin, go ahead.
I'm very confused because I've already asked if any relevant evidence was withheld as part of the disclosures, and I got an answer in the negative. Where's that document?
Objection. Ms. Merlin has never requested this document through the discovery process. She's had ample opportunity to request it from counsel to supplement the disclosures. The discovery that was provided consisted of thousands of documents that were requested by Wildgrass. It is certainly possible. This is not one of her clients. It's not one of the witnesses that she's identified in her pre-hearing statement. We've had absolutely no chance to respond to this prior to the hearing. It's irrelevant evidence.
I'm sorry, I'm a little stunned because I did provide discovery requests to Extraction, and Extraction has provided discovery, and Extraction provided us with dozens of files containing, yes, hundreds, if not thousands of pages, which we have extensively perused. I will move on from this particular person. However, I am concerned because we have also, as part of Extraction's disclosures, they disclosed to us tracking numbers from undelivered offers to lease. And now I have concerns about whether they've actually disclosed all of the relevant tracking information to us.
Is that in the form of a motion, an objection? Where are you at this time, Ms. Merlin?
I'm going to need a moment to pause the proceedings and confer with Mr. Salazar as we're consolidated on this matter. And I believe
Mr. Salazar is not an attorney in this matter.
our motion, it's very,
I tell you what, let's do this. It's time for a break. Let's take 10 minutes. That'll give you a chance to confer with Mr. Salazar. You are joint movements on something. And then we'll come back and we will reopen the case.
Can
It
you,
is
Mr. Robbins,
3:30.
I would like a copy of that document to which they are now referring, which has not been introduced to me or into evidence. If they could send that to me during the break, that would be appreciated.
Okay, let's take the break. Let's come back at 3:45 and we'll see everybody then. Okay, we're back on the record. Here's what I want to do with regard to where we were. Ms. Merlin asked a question of the witness. The witness answered the question by reference to a document that the witness has, which Ms. Merlin professes to not have. I believe that document, because it was referenced by a witness, is disclosable to everyone. Commissioners, Ms. Merlin. I'm going to ask Ms. Merlin to move on with her line of inquiry. I'm going to inform the attorneys for extraction that if their witness in answering cross-examination questions refers to a document that's not otherwise disclosed, it'll need to be disclosed.
Thank you, Mr. Robbins. I would take one brief moment, merely because Ms. Merlin has alleged that we're withholding some documents in discovery. I am reviewing and looking at my file, my personal file, of all the documents that were disclosed to Ms. Merlin on September 17th. The election letter to the Natalie A. Coratino Revocable Trust was within the files that were uploaded. It's my belief that that document was included within the share file during discovery. And to the best of my knowledge, it was included and disclosed. It was certainly not withheld. And further, Ms. Merlin's never made any requests to compel that document. We've never been on any awareness that this was in any way relevant to her claims or her case. It's being brought up for the first time here. We would certainly have cooperated if we were provided advance notice. And I can confirm that that was within the documents that I disclosed during the discovery process.
Okay, the record is so noted with your position on that. I'm maintaining sort of the ruling that I just pronounced in terms of this is our go forward plan for the remainder of this cross-examination of this witness and other witnesses down the road. So Ms. Merlin, next question, please.
Thank you. If I may just briefly make my record, which is that we did provide a discovery request to extraction. That ruling from the hearing officer on our discovery request was granted in part and denied in part. And that is part of the administrative record that you have in this case. And to the extent that the withholding of any documents has been prejudicial, then I would claim an exception to that. But I will move on now. With regard to the other parties who were provided tracking information which showed that these documents were not delivered, do you have other tracking information that indicates that those 8, sorry, maybe I should back up for a second. Do you, I'm sorry, very thrown off by a lot of things that have happened today. So isn't it true that it's your habit to send lease offers by certified mail with no signature required?
Yes.
And isn't it true that you sent all of the disclosed lease offers in this case in such manner?
We sent the lease offers and well proposals certified tracked to be delivered, to certify that they were delivered but not signed for.
Okay. And isn't it true that you disclosed the tracking information for all of the unleased mineral owners to Wildgrass as part of the pre-hearing proceedings?
Yes.
And isn't it true that of these certified mailings, at least 8 of them were marked as undelivered?
Yes,
And isn't it true that no other evidence of receipt of these offers has been disclosed?
Ms. Merlin, again, objection. You're asking the witness about
You're muted.
Ms. Merlin's asking the witness about the discovery process. The discovery process was handled by counsel. That is a pre-hearing process that is handled in front of the hearing officer. She
Mr.
referenced.
Storm, if I could, the witness may not be able to answer the question. Can we just get an answer from the witness?
Yes.
Sorry, so the answer is that it is true that no other evidence of receipt of these offers has been disclosed.
Objection. Again, the witness has no personal knowledge as to that process. If Ms. Merlin would put a document in front of the witness to apprise him of one of the offers that she's talking about, perhaps that would be helpful.
I will be happy to do so, but first let me rephrase. Is there other evidence that suggests that these offers were in fact received?
no,
Okay. How would extraction provide royalty payments to owners that it's unable to locate?
Objection. This is completely speculative, and it has no relevance to Ms. Merlin's protest, to her pre-hearing statement. It's not relevant to any of the claims that she's made in the hearing, and it's not relevant to any of the parties that she represents.
Ms. Merlin?
Yes, thank you. This is highly relevant to our arguments that it is of fundamental importance that mineral owners actually receive offers to lease. It is not simply part of the commission's rules, which it is. It is also a matter of fundamental common sense. If you have mineral owners that can't be located, to give them the offers, how are you going to pay them?
Ms. Merlin, I think this is more in the line of closing argument as it is for a question for this witness. So I'm going to
All right,
suspend the objection and ask you to move on.
I will simply ask the witness, if you'll give me a moment to screen share to authenticate the following documents.
Yeah, take your time.
Thank
Hold the
you.
time, Ms. Larson.
So I'm not sure how I can show these one at a time, but all right. Is this screen sharing working?
yes,
It is.
Okay. Is this a true and accurate copy of the tracking for David Talder and Myra Talder, who are unleased mineral owners in this tract?
Mr. Robbins, just an objection to bringing up this exhibit. Again, this relates to the pending motion, but this tracking information does not relate to any of Ms. Merlin's clients. It's going to call the witness for speculation. Thank you.
Mr. Storm, I understand, and you can just have a continuing objection along those lines. But the commission has overruled the motion to strike, and we just want to hear the evidence. So let's move forward.
Thank you.
Is this a true document, Mr. Rayburn?
sorry, we're muted. Yes, it is a true document.
Okay, thank you. And I'm not sure, did your image change?
Nope, we're still.
Okay. Can you see the second tracking for Hannah Clewin and Joshua Clewin?
Yes,
Before the witness answers, again, Mr. Storm, I'm just gonna, you have a continuing objection for each of the documents as we scroll through them, and that's noted. Go ahead, witness. Can you answer the question?
yes, it is.
Okay, thank you. This is for John Hosking and Julie Hosking. Is this a true document?
Yes,
I would, I would introduce the previous one as Exhibit 2, and this is Exhibit 3. This is for John Casey and Aaron M. Casey. Is this a true document?
yes,
This is exhibit 4.
Ms.
Justin,
Merlin,
yes,
real quick, the protestants, so that we don't overlap in exhibits, I think the protestants have been directed to label exhibits alphabetically.
Yeah, if
Thank
you could
you.
go A, B, C, D, that would be helpful.
all right, I will do that. So we'll have, I'll have to label these again for you if you wish me to actually submit copies of these to the commission for you to review. But this is, the Talders will be A, the Clewins will be B, Hoskings C, Casey's D, Justin Antis E. This is Mr. Stone. Is this a true document?
Yes.
This will be exhibit F. Margaret Keflis, this is exhibit G. Is this a true document?
Yes.
This is the Moth family. Is this a true exhibit?
Yes.
And that's, I'm losing track.
That would be H.
H,
Moth is H.
thank you. The Bender family, I guess, will be I. Is this a true document?
Yes.
And then I believe the LPL Family Trust was in fact leased subsequent to this. So we will waive that, although it's a little bit unclear.
Ms.
Yes.
Merlin, I'm
Yes.
sorry.
Mhm.
I'm trying to keep track.
Sure,
Which exhibit was E? I got Casey as D and Stone as F, but which one
Right.
was E?
so that would be 1, 2, 3, 4, 5, Justin Antis.
This is E. Thank you.
Thank you. And I believe that, so I have no further questions.
Mr. Robbins, if I could just expand the scope of my objection, just so that we cover that standing objection. Ms. Merlin was introducing those tracking documents for the purpose of stating that the election receipts were not tendered. I mean, that's hearsay. Ms. Merlin has not introduced any of the named witnesses in her statement that would allow them to speak to that document or allow extraction to cross-examine. It's the exact purpose of the hearsay law. So I need to expand the scope of our objection.
And if I may respond to that objection, first I would state that those are authenticated documents, number one, that are from the United States Postal Service, which is a government agency. B, hearsay is admissible in administrative proceedings. Coates versus Califano, 474 F sup 812, District of Colorado, 1979. As a general matter, hearsay is admissible in an administrative proceeding and can
Ms.
constitute
Merlin,
substantial evidence. Yes,
Okay, and we've let the documents in, and the
Okay.
commission will give them the weight they deserve.
I appreciate that. Thank you.
And so you're done with your cross-examination?
I am done with my cross-examination of this
Okay,
witness.
if you could stop share screening,
I will.
and then I would turn back to Mr. Storm and Mr. Pashala. Do you have a second witness for us?
Just one moment, Mr. Robbins.
Mr. Chair,
Commissioner Messner.
thank you. Just a point of order. It appears that the counsel for extraction is conferring with witnesses prior to the witness answering questions. I believe that's inappropriate, and so would ask that that not occur in the future and that the witness answer the questions, understanding that counsel has the ability to object and to participate in that. But this commissioner doesn't appreciate counsel guiding witnesses.
Thank you, Commissioner Messner. I think we all would agree with that. So let's let the witnesses speak for themselves. And I can't see you guys close enough to know whether that's happening or not, but you know better. So come on, let's move forward with the next witness.
May I ask how much time Extraction has remaining left in its case in chief?
Ms.
Yes,
Larson?
Yes, thank you, Ms. Merlin. Extraction has 49 minutes and 37 seconds, and if you give me a moment, I will provide you, Ms. Merlin, your time. You have 1 hour, 20 minutes and 32 seconds. You've used 9 minutes and 28 seconds.
Thank you.
So, Mr. Robbins, I'd like to call Jason Rayburn just for some redirect. Mr. Rayburn, I would like to refer to Exhibit 8. And Mr. Rayburn, are you familiar with this unit? Or with this exhibit? I apologize.
Yes.
And can you explain what this exhibit is?
This is Rule 530 for polling proceedings effective up until December of 2018.
Okay. And
Is it just me or folks not seeing? I'm
Yeah.
just seeing,
All we're seeing is a PDF of Exhibit 8, Rule 530. We're not actually seeing Rule 530, if that's what you're planning on trying to do. Like, click on it and open it up, if that's your intent.
So they're only seeing the window.
Okay, thank you.
Yeah.
And Mr. Rayburn,
Going.
you are familiar with Rule 530 as in effect at this time?
Yes.
And in your understanding of Rule 530, did the rule require consideration of lease terms in quartering and contiguous units when the lease at issue did not exceed the unit?
At that time, no.
Okay. And is that located here on the rule?
No, because it doesn't exist at the time.
Mr. Rayburn, if I'd like to direct you to Rule 530C here. Perhaps refresh recollection here to this clause. Are you familiar with this portion of the rule?
Yes.
And I'll give you a moment just to refresh. In your understanding of that portion of the rule that states that it shall continue consider quartering and contiguous units that are under the proposed lease, is the lease that is offered to Wildgrass's protesting members, do their tracks exceed? Do they go outside the unit?
No, they're contained within the unit.
And so in your understanding of the rule, would quartering and contiguous unit information be relevant evidence in this hearing?
No.
Would it in fact be perhaps unhelpful in this hearing?
Yes.
Okay, thank you.
And I would like to reiterate our objection, just for purposes of creating a record, that 530 is no longer the applicable proceeding, the rule, because this is a pending proceeding, is not retroactive effect. So that's our objection. And I'm sorry, I have a citation. It's In re Estate of DeWitt, 54 P3D 849, Colorado, 2002.
Thank you. Go ahead with your questioning, Mr. Storm.
Just a few more questions, Chairman Robbins. Mr. Rayburn, and then are you familiar with this portion of the exhibit?
Yes.
And I'll give you a moment just to review this rule. But after this is the rule a little bit later, in your understanding of the rule, did the rule require consideration of terms that are outside of the unit when the lease did not, when the lease was contained within the unit?
At that time, no.
Okay. And again, is it your testimony that the Wildgrass Party's interests are entirely contained within the United South?
Yes, the leases offered are completely contained within the unit.
Okay. Mr. Rayburn, Ms. Merlin asked whether extraction required signatures in its election letters. Is a signature requirement, is that required by the commission rules at any time when the election letters are going out?
No,
Is that required by the act?
no.
I would just object. I did not suggest that it was the signatures that were relevant.
Overruled. Let's let them do their direct examination, Ms. Merlin.
Ms. Merlin, could you please put up your exhibit 2 that you just put up?
Mr. Storm, you'll need to stop share for her to be able to do that.
I'm sorry, exhibit 2 or exhibit B? I'm a little confused now.
Referred to it as exhibit 2. It might have been renamed exhibit B.
Which one are you speaking about? Are you speaking about the list of
Yes,
okay.
the
all right.
list and testimony.
Is this the exhibit you're referring to? I
Yes,
think just to avoid confusion, we'll label this exhibit K.
And Mr. Rayburn, Ms. Merlin stated that this was the application. I cannot control it, but Ms. Merlin, would you move up to the top of this exhibit? Is this document in fact the application? First of all?
I'm not at the top yet, sorry.
Can we go a little bit farther down
Okay.
to the top of Mr. Rayburn's testimony?
Mr. Storm, tell us when to stop.
Right there. That's great. Thank you very much.
Okay, right there.
Farther down. I'm sorry.
This land testimony?
Yes.
Exhibit A of within exhibit, okay, yeah, sorry.
Mr. Rayburn, is this a copy of the application?
No, this is testimony.
And are you familiar that after SB 19181 was passed, some limited testimony was filed to update the applications in compliance with the act? So good faith and 45%.
Yes.
Is that what this in fact identifies?
Can you scroll down? Continue.
This was signed on the 29th day of March.
Well, proceed down a little bit farther, Ms. Merlin. If we can go to the list. Ms. Merlin asked if this was a copy of all interested parties within the application. Is that what this list is?
No.
Okay, yes, thank you. And does this list merely show those unleased and working interest owners who are to be deemed non-consent?
This list shows the unleased owners and working interest owners.
Thank you.
Sorry, I will scroll through just the rest of the list, just so we can see that there are approximately almost 300.
Non-consenting, nobody's not consenting.
I'm not sure what RI.
I'll take back over the screen if you could.
And I would like to also object, I'm very confused here. They're now saying that Rule 530 does apply by filing notice of 45%, but that it doesn't apply in other situations. So I don't know what my objection is because I don't know what they're trying to say. I guess I object. I think they should stick with the version of the rule that, and not just, yeah.
I'd direct both sides to sort of address this issue in closing. Mr. Storm, did you have any further questions on redirect?
We have no further questions. Thank you.
Okay. At this time, do you want to call your other witness, Mr. Bennett?
We do not wish to call Mr. Bennett at this time.
Okay, do you close your case then?
That's the completion of our case.
Okay. All right, we do need to keep going this afternoon for probably at least another hour so that we can get through all of this today and tomorrow. So, Ms. Merlin, I believe that you're up.
Thank you, Chair Robbins. We'd actually intended to do some cross-examination on the issue of the ongoing production that is occurring in this unit. However, I suppose we won't be able, do you mind if we take a quick break to just deal with a couple of things off screen?
Sure, how much time do you need?
10 minutes, 10 minutes.
Okay, let's come back at 4:20.
Thank you.
Okay, it looks like we're all back. Ms. Merlin, I believe we gave you the chance to huddle with yourself or with Mr. Salazar, and I think you're up next in terms of case presentation.
Thank you, Chair Robbins. Yeah, I don't wish to prolong this hearing longer than necessary. And in fact, I think that Extraction has made our case for us. We will not be presenting witnesses today. I would just like to read a couple cases into the record regarding the applicability of Rule 530, which would be the City of Greenwood Village. Yes.
Hold on just a second. Okay.
Yes.
So if you're not going to present witnesses, and then I presume, Mr. Storm and Mr. Prashala, you don't have any rebuttal since there was no case there. So I think that we're at the point where the case that
I
we're
would like
dealing-
to, sorry, I would just like to ensure as a procedural matter, I did introduce evidence during my cross-examination of Mr. Rayburn. I would like to ensure that it is accepted, if necessary, to reiterate during my case in chief, our exhibits A through K.
Yes, exhibits A through K are admitted.
Thank you.
Okay. So at this time, I believe, hold on, let me get my case management order. Yeah, so now at this time, docket not 190400289, that we've received the information on it. And I believe we would then turn to a 5-minute closing from each side. AG Davenport, do I have my ducks in a row there?
Apologies, Mr. Chair. Yes, I think so. And my understanding is that Wildgrass has just indicated they're not going to present any witnesses, any further witnesses, any further information for their case. And so this case stands essentially submitted, the evidence, and we can move to closings and then commissioner questions.
Okay. Mr. Storm, Mr. Prashala, are you ready for closing argument?
I'm sorry, Commissioner Robbins, we are ready for closing statements.
Okay, I believe each side has 5 minutes. You can reserve some of that time for rebuttal if you desire. That's up to you. Hearings manager Amaro is keeping time at this point, so I think the floor is yours.
Thank you, commissioners, and thank you for taking the time this afternoon to go through that testimony. I understand that it's dry, but it was part of the pleadings that have to be addressed. In all respects, Extraction's application is eligible to be pulled. First, Extraction owns or has obtained the consent of more than 45% of the interest to be pulled in the United South unit. In fact, the evidence today has shown that Extraction owns more than 77% of the working interest within the unit, covering a total of approximately 982 acres. Second, Extraction has engaged in good faith, reasonable leasing efforts with each of the unleased mineral owners within the unit. These efforts include negotiation of terms with multiple mineral interest owners within the DSU, encouraging mineral owners to reach out to its agents with any questions about the leasing process, and observing reasonable commercial standards of fair dealing throughout its pre-pooling process. This approach led Extraction to obtain dozens of leases within the United South unit. And further, Extraction has specifically attempted to negotiate the lease offer presented to the unleased protestants, but those attempts have not been responded to by protestants. Third, Extraction's lease offer was reasonable and commensurate with the prevailing rates in the area. Extraction has shown the commission that Extraction's lease offer provided a more than fair shake, a chance for each mineral owner to lease their minerals and obtain competitive terms and rates for their interests. In fact, Extraction and other operators obtained oil and gas leases from numerous owners within the same unit of the protestants at the same or comparable terms. Further, the protestants have shown no evidence today showing that any of the terms at issue are below market rate. This offer to the protestant, which is a 4,500 acre bonus, a 3-year term, a 20% royalty, and no surface occupancy, among other terms, has been shown to be reasonable. Fourth, Extraction's Rule 530 election letter, on which this pooling hearing is based, was tendered to each owner at their last known address, including the protestants. The evidence has shown that more than 60 days before the hearing for this matter, Extraction sent an election letter to the last known address of all owners within the unit. The letter provided the location and objective depth, fair and reasonable drilling and completion costs, owner share, anticipated spud date, and afforded a sufficient election period allowed for under the rules. The letter included the commission's pooling brochure and complied in all other respects with commission rules and standards at that time. Finally, based on Extraction's examination of relevant contracts and records, all owners of an oil and gas interest in the tracts to be pooled for this hearing could be located by Extraction, received timely notice of the application as provided for under COGCC rules under the Act. Despite the protestants' claims to the contrary, Rule 530 and the Act simply do not require personal service of election letters. The Oil and Gas Conservation Act provides the commission shall not enter an order of pooling an unleased non-consenting mineral owner under subsection 6 of this section first over protest of the owner unless the commission has received evidence that the unleased mineral owner has been tendered no less than 60 days before the hearing a reasonable offer or furnished in writing the owner's share of the estimated drilling and completion costs. Rule 530 at the time of the election letters provided for 35 days written notice, and personal service is simply not required under Rule 530 or the Act. This was the finding of the commission in order number 407-3006, a similar pooling application protested by an owner who argued that he had failed to receive his election letter. In that matter, the hearing officer found, and the commission adopted this finding, that the protestant also asserted that they had never actually received the election materials. However, the Act and Rule 530 do not require that the non-consenting mineral owner actually accept and read the election materials. The Act is clear that the commission needs evidence that an unleased mineral owner has been furnished in writing the election materials. Similar, Rule 530 requires written notice of the election materials. Rule 530B, although Rule 530 does not specify how such written notice should be delivered, the commission rules provide that general notice shall be provided in accordance with the requirements of 3460-108-4 CRS. Under that statute, notice must be given either by mailing a copy thereof, postage prepaid to the last known mailing address of the person to be given a notice by personal service. In the present case, the owners that allegedly failed to receive their election letters are not protestants to this hearing. They have never otherwise objected to this hearing, and they are not represented by WOGC. It would be improper to speculate as to why they have chosen not to receive the election letters that were tendered, but nonetheless, Extraction has complied with the rules. The evidence indisputably states that Extraction has complied with the rules in the Act in this matter. Cool. Thank you.
Thank you for that. Hearings Manager Amaro, was there any time remaining?
Yes, there was 2 seconds left.
All right, we got a quick rebut. Ms. Merlin, you're up next.
Thank you very much. And thank you very much, commissioners, for your time this afternoon and the time we'll spend here tomorrow. This is a lot of time that's been allocated for proceeding with such a fundamental flaw as not providing offers to unleased mineral owners, which is a fundamental requirement. I think we've hit on that sufficiently, and I don't wish to belabor the point any further. We have given Extraction ample time to cure this defect prior to arriving at this point. They were put on notice that a protest would be occurring, at which they would be required to submit evidence showing affirmatively that they have met the burdens. We filed a motion to dismiss, not to be obstinate, but to save us all the trouble of coming to hear about whether lease offers were reasonable when in fact they weren't provided. Extraction bears the burden in this case of submitting sufficient evidence in support of its application. Issue 1, did every unleased mineral owner receive an offer to lease? And 2, was that offer reasonable? Extraction failed to submit evidence that all unleased owners received offers. They in fact admitted that they did not. And they did not submit any evidence regarding leases in adjoining or contiguous areas as required by Rule 530. And therefore, we believe that their application simply fails. This is not an incurable defect. As we mentioned during our opening argument, that it takes substantial time and resources to determine who is an interested party, who owns mineral interests, who has been a leased owner, what are the successors in interest. And after taking that time and trouble to not take the time and trouble to ensure that offers are actually received by these owners is somewhat mysterious. As I also mentioned during my opening argument, it took me moments during a Google search to track down several of them, and in fact reached 2 of them by telephone. This is not a magic mystery. There is a financial motive for Extraction to prepare lease offers and put them in the mail and yet have them not be received. They save a substantial amount of money by having unleased mineral owners involuntarily pooled, as opposed to actually receiving fair and reasonable offers to lease. So, I would also suggest that the purpose of pooling, it's important. It was originally developed as a means of protecting correlative rights. We've actually heard in pre-hearing proceedings that were not raised today that Extraction has begun drilling in this unit, and that it would simply drill around the unleased mineral owners. We do not dispute as an engineering matter whether that could be technically possible. However, we would say that does blow a hole in the concept of involuntary pooling as a fundamental premise if you can simply frack around unleased mineral owners. So again, not trying to belabor the point. However, we believe that Extraction has failed to meet its burden of proof. We thank you very much for your time, and that's all I have to say.
Thank you, Ms. Merlin. Thank you, Mr. Storm, Mr. Fischella. At this time, I believe that the case is submitted. I do want to inquire of my fellow commissioners if anyone has questions of either side following the closing arguments that we just received. Commissioner Messner.
Thank you, Mr. Chair. And I'm sure that I've missed it somewhere because I know it's in the record and has been indicated a little bit, but perhaps Mr. Storm, can you indicate how many unleased mineral owners who were sent a lease turned out to have a tracking number associated with that mailing to be undeliverable?
No, we don't have that calculated today, but we can go through our USPS mailings that were provided to Ms. Merlin and get that number for you if you'd like.
That would be great if you could do that. I'd be interested in knowing the specifics around it as well, as far as who the unleased mineral owner was and whether or not it was undeliverable.
So there's also the question as to whether the actual status of what the United States Postal Service gives to that designation. Undeliverable, from what I understand, can mean that they were given notice to pick up their parcel at the post office, and whether they declined to go retrieve that parcel is up to each individual.
So let me phrase it a different way then. I would be interested in knowing a list of the unleased mineral owners that did not have a confirmed delivery status.
Understood. Yes, I can provide that.
Okay, thank you.
Anything else from commissioners? Commissioner McGowan?
Thank you, Mr. Chair. I think my question is for Ms. Merlin. In 506A, it says mineral interests owned by a person who cannot be located by the applicant through reasonable diligence are not included for the purposes of determining the 45% mineral interest threshold. Does that not imply in our rules kind of an understanding that there might be some folks that even if the operator put in due diligence and a good effort, that they would not be able to locate those folks? And therefore you would still move forward with pooling?
Thank you very much for that question, Commissioner McGowan. First, I would say that provision exists in both Rule 530 and 506, whichever you apply, and that it does say that for the purposes of determining the 45% threshold interest, that the application of diligence and undiscovered owners is a factor. And to be honest, I'm really not sure why that is in that rule. It's the only place that language appears. Typically, when you're constructing law, statute, rule, if a word or phrase appears in one place and does not appear in another place, then you should significance to that absence should be imparted. The rule, the plain language of the rule is very clear that unleased owners have to receive offers. And I think the reason it makes a lot of sense, it may be at the beginning of a proceeding when they're trying to establish a minimum threshold, perhaps the lower standard makes sense. But when you've gotten all the way to the end of a pooling proceeding, to not be able to locate the mineral owners. And one thing I have to say is that there was no showing of diligence. Extraction not only did not provide evidence that these, they didn't provide any evidence as to diligence. And in fact, I understand it doesn't count as evidence, but I was able to locate several of those people using a Google search, and I'm not an investigator or anything to that extent. So I think that to the extent that you would be interested in taking notice, you'll find that these people are not impossible to find. If you can track down a lease from 1982 and track all of the successors and interests to name them as interested parties, I think you would be able to find the mailing address for them. But that's not what the rule says. The rule says they have to receive them.
Thank you. So I think another piece for me is that the rule says that, sorry, and now I have to find the language, that the notice and the offer has to be, sorry. The owners were tendered a good faith, reasonable offer. And so if the operator has hired this title company, has done the research, came up with a mailing list, there is kind of a problem for me of you can't force someone to open a piece of mail. You can't force someone to sign something and accept it or go pick it up. So what happens in those instances? Is that operator never allowed to pool?
So thank you for that question. I am not aware of a situation in which a person would go to a post office, see a package is from Extraction Oil and Gas, and tell the clerk, no, I don't want to accept that. If the post office drops off the package, I'm not sure.
So have you ever gotten mail that you didn't open?
Yes, but the post office would have marked it delivered if it was certified mail, whether I opened it or not.
So could there be an example where someone was tendered the notice but never opened it, and then later said, I didn't get anything. I am a mineral owner, but I didn't get anything. I think I'm struggling with like how much effort is due diligence and a good faith effort on the part of the operator and the responsibility of the person receiving the information.
Yes, and I respect that. And if these were simply unleased mineral owners coming to you and telling you, gosh, I really don't remember receiving an offer. I can't say, I throw away a lot of mail. That would be different. But the language about tendering an offer is not located in the same section of the rule as the standard of proof that is required to pool unconsenting mineral owners. Now, if Extraction wants to claim that it can pool around those unconsenting mineral owners, as it claimed in judicial review proceedings yesterday, then that is their argument to make. But first of all, they received notice that these mineral owners did not receive their offers. They had that information back in 2019. They had all the time in the world to attempt to correct that mistake, and yet we've seen no evidence that they even attempted to correct that mistake. So I would not say that that's diligent, and certainly I would not, as the protestant, I would not be willing to just assume that there was diligence there when they have not testified to any efforts of that nature. Even if diligence was part of the rule.
So theoretically, are you saying, let's just say the operator knew there were 10 mineral owners, had the last address for all of them, and simply could not find the last mineral owner. Can that operator then never pool?
I'm not sure in that hypothetical situation. I'm not sure if that hypothetical situation has arisen in the past. I think if the commission has rules that say that shouldn't be the case, then they can you can have a rulemaking and you can rewrite the rules. But it's not appropriate here. And actually, I do think that some extra effort, rather than simply putting it in the mail to the last known address, is required. After all, we are talking about valuable property rights here. And as I brought up earlier, if you don't know how to find these people to offer them leases, how are you going to pay them their royalties? These people will be entitled to money from Extraction, and it's your job as the commission to ensure that these rules are followed to protect mineral owners from having their minerals taken without compensation. Yeah, that's what I have to say about that.
Okay, and then just for clarification, none of the folks that you're representing are saying that they did not receive a notice or an offer. Is that correct? You are saying that you did some research on your own and believe that you found owners who had not been contacted.
Thank you, Commissioner McGowan. I do appreciate you giving me the opportunity to address that legal argument that was raised by Extraction, that we should not be permitted to introduce this evidence based on a lack of standing. And I will note that several matters. Number one, this is not our burden. I cannot reiterate that enough. We are not tasked with the burden of providing evidence that they failed to do something. They simply have not produced the evidence that they did do it, and we're pointing that out. We are not raising claims on behalf of people. This isn't a civil suit. We have standing to protest. Our standing to protest this application has not been challenged. We are introducing relevant evidence. Relevant evidence is to be considered. The rules of evidence say that if it is relevant, meaning that it has a tendency to make a pertinent fact more or less likely, then it is relevant and will be admitted unless there's a specific rule under which it should be excluded. And in administrative proceedings like this one, I believe the statute is CRS 244105. I have to double check that, but the rules of evidence are to be relaxed in the interests of justice, and so we don't need standing to introduce relevant evidence. We have standing to participate in this proceeding, and this evidence is relevant, and it's in front of you. It can't be disregarded. Extraction has not complied with the rules as you have set them forth.
Erling, could you now answer Ms. McGowan's question?
What was, sorry, I thought I did. What was?
Sorry, but your clients, the folks in Wildgrass, did get notice and offers. And
Yes,
the other part of your issue is what was in those offers, correct?
So yes, we do have unleased mineral owners as members that we represent. So our members are being pooled by this application, but we have not claimed that our members did not receive offers. We did question the reasonableness of those offers.
To answer the question, your clients that are members of Wildgrass did receive offers.
Yes, to my knowledge, they did.
And the folks that you're alerting us to that did not receive offers were not your clients.
Correct.
Thank you.
Thank you. Thank you. That's all I have. Thank you. Thank you.
Commissioner Gonzalez.
Thank you, Chair. Ms. Merlin, if a party did not receive notice to a pooling application and it went through, was approved, the matters were pooled, the interests were pooled, and they later discovered they did not receive notice, do they have a means to correct that?
Well, first, I want to be very clear that the standards for notice and offers are different. Notice is a much lower threshold where putting it in the
offers
mail
then, yeah.
is sufficient. So in the case, if an unleased mineral owner had discovered that they had been involuntarily pooled without their ability to participate, I believe that I believe actually Mr. Davenport testified yesterday in judicial proceedings that they would have the ability to reopen the pooling, pooled unit. They'd be able to reopen that order for reconsideration. They would probably have not gotten paid for those minerals, and so they would probably have the ability to bring civil trespass claims as well. I think that that's one reason why your rules require receipt, is to prevent that type of situation from arising whereby pooling orders are never final. I'm also not sure what would happen to the other mineral interest owners. Let's say that the person who didn't receive the offer owned 50% of the minerals within that pooling unit, and the production had been going on for 10 years. And the proceeds from those royalties had been distributed to all of the other mineral owners in that unit. And this owner had not received their share. Their share had actually been distributed to the other owners, or kept I honestly don't know what would happen to that share of mineral interests, but in this hypothetical, how could they claw back those proceeds from the other royalty owners who had been paid, an unjust share of the proceeds?
Ms. Merlin, I don't think that someone's lack of being pulled means they're not going to get paid. It's the mechanism for which they are paid, whether they are paid under a lease, under a statutory term, or whether they're paid 8/8 to their interest. So I think if there's an interest that's accounted for, that interest gets paid regardless. And if they can't reach that owner, and my understanding and my experience is that it's placed in suspense until they can. I see AG Davenport's popped up on video. So do you have anything to add, Mr. Davenport?
Not unless Commissioner Gonzalez, you have a question. Frank, I just heard my name.
Oh yeah, well, you're being paraphrased by Ms. Merlin. I think she did an accurate job of representing what the mechanisms are for someone who did not receive a notice or wanted to contest whether or not they received a reasonable offer, that they have the opportunity to reopen and vacate an order by this commission for pooling. And so I think I got the answer I was.
Okay.
I got the explanation I was looking for, I suppose.
Okay, yeah, and just to clarify, if I agree that I did in argument inform the judge yesterday and maintain that if this commission puts into its every single one of its orders that it may be modified or vacated after notice and hearing, and that applies to pooling orders as well. If someone disagrees, any person, no matter how long after the fact it is, that something that they didn't get notice of or whatever, a commission order is wrong, they at least have the opportunity to file an application to have that order modified.
But I would just reiterate and bring you back to Rule 510, which says that you shall not hear a matter in which the evidentiary burdens have not been met. So.
Thank you, Ms. Merlin. Commissioner Gonzalez, unless you have anything further, I was going to give Mr. Pashala or Mr. Storm an opportunity to speak to this inquiry so that we're hearing from both sides. Mr. Storm, if you want to unmute, and you don't have to, but I didn't know if you wanted to weigh in.
I think it's a good idea, but I think that question's better directed to Mr. Rayburn.
I raised my hand for Commissioner Messner, had a question about how many individuals have a designation of unclaimed or undeliverable. We have 42 unleased mineral owners in the unit, and 11 of those either did not pick up their, are marked as undeliverable or do not claim their parcel.
Thank you.
And
looking,
Mr. Robbins, I'm not sure if you wanted us just to respond on kind of the effect of pooling and what that whole process was, but I generally agree with a lot of the analysis that Mr. Gonzalez, Commissioner Gonzalez laid out. Pooling these interests, unleased mineral interest owners have a remedy to pool their way in and change their status if it was shown that for some reason extraction did not comply with the rules with respect to their interests. And two, that the pooling does not in any way impair the way that costs and revenues are calculated with respect to those parties' interests. Typically, if those parties are identified, and I think that the record showed that the addresses were all correct, but for some reason they may not have been picked up or received, that those revenues would be paid out, distributed. There would be a division order that person would sign, and they would have an opportunity to get paid on that. If it was in fact that person could not be located, then I would agree with Mr. Gonzalez that the interest would simply be held in suspense for a period of time. I think the Colorado law provides for about 7 years before, at that time, I think there's a process for a sheet. But I do not believe that the pooling order would allow revenues to get commingled and in a way lost, irreparably lost in the way that this brother described.
I'm sorry, I just want to point out, we've talked about packages not getting picked up, and I have submitted into evidence these tracking numbers for undeliverables, and I will note that among them, I don't see any that are post office boxes. These are all street addresses, so I don't know what to tell you there.
Thank you, Ms. Merlin. Are there any further questions? Okay, I'm not seeing further questions. AAG Davenport, should we close the record on 1904-00289? You're muted, Kyle.
Thank you, Mr. Chair. I think that makes some sense. And the reason that I say that is this: there are actually two different matters, docket matters, that you will hear. The other one starting tomorrow, the one ending 458 starting tomorrow. I do think it makes some sense to maybe close the record on 289 to have a clear demarcation of which evidence is submitted in which matter. If that makes some sense to you, Mr. Chair, and the commissioners. You always, commissioners, have the option to reopen the record should you decide you need to later in deliberations, for example, on both of these matters. But I think a clear demarcation of when evidence in one docketed matter is being submitted ends and another begins makes some sense.
Okay, I'll look for a motion to close the record in docket 1904-00289.
So moved.
Second.
We have a motion and a second. All those in favor of the motion signify by saying aye.
Aye.
Any opposed? Okay. Docket number 1904-00289 is closed and is deemed submitted. I would suggest to commissioners that we take up docket 1906-00458 tomorrow morning at 9 a.m. when we reconvene the commission hearing. I also would suggest to commissioners that we take a 1 hour and 4 minute break and reconvene at 6 p.m. this evening via Zoom for the one public commenter that we have that signed up. Is everybody okay with that? All right, see you in 1 hour and 3 minutes. All right, welcome everybody to the Colorado Oil and Gas Commission evening edition of our meeting. This is November 17th, and we had a meeting starting at 12:30 today, and we got through our agenda. And this evening we have just a short meeting. We have one person that has signed up for public comment, and the only other thing on our agenda is commissioner comments. Don't see our person that signed up in the meeting yet, so let's give her a little bit of time. It is Jenna Parker. And then Janice Brown, thank you very much, Ms. Brown, provided written comments to us that the commissioners have reviewed. So with that, would look for if anybody has commissioner comments. And I can start. I think most folks know, but I am the appointed representative to the IOGCC, the International Oil and Gas Compact Commission, which is a multi-state thing in which states show up, and once a year we have a meeting, and every now and then they pass resolutions. And I attended their meeting last weekend on behalf of Colorado. We had a lot of good information sharing about what states are doing, what they're not doing, issues that are out there for states, et cetera. There was a lot of talk about the infrastructure bill that was signed on Friday night, because we were meeting on Sunday, and that infrastructure bill will have upwards of $4.5 billion going to states to address orphan wells. So I know our team is working hard on the next steps for that, and I think that'll be a good thing for our orphan well program. I can say that we are fortunate to have a robust orphan well program led by Mike Hickey and led by an engineering manager, Dave Andrews. And that's going to be helpful for us with regard to the receipt of federal funds to continue to address those issues. So there was a lot of talk about that. We had a lot of discussion to learn about what other states are doing, and also for me to inform other states about what Colorado is doing. I'm proud about what Colorado is doing, and was happy to be able to shine a light on how things are moving forward in Colorado under our mission change rules and moving forward with OGDP considerations, et cetera. So I thought it was a great meeting, and I was happy that I was able to attend. So that's basically my update. Anybody else have ideas or comments at the commissioner comment stage? Everybody's exhausted after our hearings today, which is perfectly fine. I'm buying time because we still do not have Miss Parker in the house. So let's give her a little more time, and then we will have that one public comment before we move forward. All right, rather than just sort of sit here online, let's all come back at 6:10, because that's the time that we informed folks that we would take public comment. So you all just got yourselves 5 free minutes. Okay, hello, folks. Well, I can say that we did our best. It is now 6:11. We indicated that public comment would start at 6:10, and our public commenter has not shown up. So with that, I would look for a motion to continue this hearing until tomorrow morning at 9 a.m., in which case we will then take up the remaining matters on our agenda.
So moved.
Second.
We have a motion and a second. All those in favor signify by saying aye.
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 We're adjourned. We'll see everybody tomorrow morning, 9 a.m.